This is the FM Gold channel of All India Radio. In the program News Analysis, we now bring you a dialogue on constitutional status to Judicial Appointment Commission and implications thereof. The participants are Dr. Surat Singh, Advocate Supreme Court, and J. Venkateshan, Legal Correspondent, The Hindu.
Dr. Surat Singh, Union Cabinet has given its nod for this Judicial Appointments Commission to take care of the transfer of judges and as well as appointment. This is basically based on the Parliamentary Standing Committee's decision. So they have given a report. Earlier the bill was passed by the Lok Sabha. After that Rajya Sabha they were referred it to the Standing Committee. Now Standing Committee has suggested some changes. So as per the revised bill proposed by the Union Cabinet, new Article 124A will be introduced in the Constitution, which will define the composition of the Judicial Appointments Commission. Then Article 124B will be introduced, which will define the functions of the Judicial Appointments Commission. So do you think that this Judicial Appointments Commission will augur well for the appointment of judges as well as for transfer? Because you are taking away the present system and giving it to a new experiment.
There are 2 points. First, while I appreciate this bill which is more participative and it will also give transparency, we should also express our gratitude for the system which earlier was there, because even when collegium were appointing judges, the quality of our judges were very good. But in democracy there should be more participative, more transparency. And here also, out of 6 members, Chief Justice would be heading the commission. Then there are 2 collegium senior-most judges, the Law Minister, which is a part of the government, and 2 eminent persons, one by SC, OBC through rotation. It's a welcome step in an inclusive democracy, because ultimately law is passed for the benefit of the people, not for any particular section of the society. So it's very important that the views of that various groups of the society, represented through 3 eminent persons, are represented there. So to that extent, it's a welcome step. Earlier also, when Constitution was enacted from 1950 till 1992, government was playing a very important role. That is, it was in fact government which would be appointing the judges along with concurrence of Chief Justice. It was in 1992 only when Supreme Court Advocate on Record Association case, Supreme Court said no, 3 senior-most judges would be constituted in the collegium. In 1998, 5 judges would be constituted. And in 15 years, there are certain achievements which we do not have to forget. For example, judiciary has really, in India, has come out strong, particularly Supreme Court, where some remarkable judgments have been passed. For example, CNG case to improve the environment, so many corruption cases,
Enlarging the scope of
media, guidelines. So, my concern would be that how do we keep those benefits which were there of total independence of the judiciary on the one hand, and at the same time how to take the advantage of this broader, more participative structure which will recommend judges.
There was one perception as far as government is concerned. So government is of the view that earlier when the executive were appointing the judges, the quality of judges was good. But after the collegium system came into work from 1993, by virtue of this 2 judgments, 93 and 1998, the quality of judges is deteriorated. That is the perception of the government. But they also said, because I had a talk with the Union Law Minister Kapil Sibal, so he was telling that by and large the system has worked well. But in certain areas, in certain high courts, there has been that favoritism, nepotism has crept in. So judges were recommending their own nephews, and a common man was unable to enter the judiciary. So that was a common grievance of the government. Now, by enlarging the scope of this National Appointments Commission, do you think that the perception will go away or there will be more government interference?
There are 2 points I will make, Venkateshwari. One is that the quality of judges after the collegium by judges was no way inferior to the quality judges appointed by the government earlier in terms of quality. But as we say, justice is only not what we done but appear to have been done. In terms of social perception, having more democratic participative process is always welcome. So as far as the quality of the judges are concerned, it has not deteriorated after collegium. But you are right to the extent that if common man's representatives are there, because after all common men are bound to be the end users of the judicial system, so more the merrier in the representative process. To that extent, it is a step in the right direction, because still now the Chief Justice would be there, two senior judges would be there, then three eminent persons, and then law minister is also there. So it's a more balanced system. But kindly keep in mind, even in America, President of America appoints the judges, but they are confirmed by the Senate, which is the legislative wing. So it is a balance of power between three wings of the government, so that no wings of the government arrogate power to itself totally. Either it's parliament or judges. So it's a check and balance.
But do you subscribe to the view that because of this collegium system, nepotism and favoritism has crept in? Do you think that
Venkateshwarji, human nature is that whosoever being the government, whether it's the judiciary, whether it's legislature, you might see even in parliament, even in government also, because that family-oriented mentality has not gone. So, to some extent, power can be abused by any wing of the government, and judiciary no exception, but having the system by which you have more participative process is always more welcome.
Now that the National Judicial Appointments Commission will get the constitutional status, just like Election Commission, so do you think that the independence will be protected, or do you think the more powers needed to be defined in the bill itself?
Well, as far as the judicial independence is concerned, since it's a constitutional status earlier also and now also, so as far as the independence of judiciary is concerned, it will not be affected at all, because of simple reason that even in Judicial Appointment Commission, the dominance of the opinion of Chief Justice and two judges and law minister is already there. So to that extent, the danger to judicial independence would not be there. Second, the judicial independence in India since last 60 years have been a very sustained thing. It is not a temporary thing. So it has come to stay. And our judges, by their taste, temperament, training, also are quite independent-minded. So I do not fear any danger to the independence of judiciary by this Judicial Appointment Commission.
The Bar Council of India has taken a view that without seeking review of the 93 or 98 judgment, the collegium system is in place. Without the government seeking review, you can't tinker with the present procedure. That seems to be the present position of the Bar Council of India. So they have already represented to the government that you can't tinker with this, don't take the bill forward.
With great respect, amendment to any judgment of the Supreme Court can be made by the Parliament by two-third majority in this case also. So that power lies with the Parliament. Ultimate word lies with the Parliament being representing the people, not with the judges. So to that extent, saying that without review you cannot change the situation is not legally and constitutionally correct. Constitutionally, amendment is allowed as long as you have two-thirds of the majority. You can pass the amendment, and any decision of the Supreme Court you can overrule. That can again be subject to judicial review. That's a different thing. But Parliament can pass such laws.
So given the fact that the government will last only for till February end, after that the Election Commission will notify the elections. So no major decisions can be taken. So this time it will be the government will go for a vote on account, and then there won't be any regular budget session. So given the shortage of time, do you think that there is scope for the bill getting passed by a majority of two-thirds, the constitutional amendment bill, as well as it gets ratification by at least 50% of the states? Do you think that this is possible in the present Lok Sabha?
The very fact that many amendments have been made in the bill to appease various sections of the Parliament, so to that extent it seems that now there is a much more unanimous opinion about this participative bill, where because of simple reason that both BJP, Congress as well as other parties also wanted to be more inclusive. The very fact that now instead of 2-3 eminent persons would be there, including one SC, OBC member by rotation, so that should be satisfying other parties also which were raising objection. So on the whole, it will sail through.
See, the one reason given by the government is that now at least about 275 vacancies are there in judges' appointment. So if the appointments are to be filled up expeditiously, then this Judicial Appointments Commission should be put in place expeditiously. So that is the one reason which the government is pushing through the bill. But do you think that the present collegium system is the reason for the delay in filling up the vacancies?
No, in fact, on the contrary, the collegium system several times have recommended appointment of judges. It is the government which have been not providing the infrastructure, have been not passing the recommendation. It goes before President for his assent. In many cases, several Chief Justice of India, one-to-one conversation has told me that so many times they have recommended the appointment, but the government has been sitting over it. So government cannot blame judges for its own delay. It is the government which has been delaying. It is not the collegium. But now Judicial Commission will be time bound and it will be much more a regular body. So to that extent it will help in expediting the appointments of judges.
Parliamentary Standing Committee has given a suggestion that considering the fact that at least 800 posts are there for High Court judges, the one National Appointments Commission, it will not be possible to fill all the vacancies. So there should be state level commissions. Do you think that unnecessarily it will become an unwieldy exercise? The present system itself will work well, or you will require further decentralization?
The trouble would be if it is a state level, then the role of regional forces, even in judiciary, would be much more there. I would be more comfortable a national commission appointing even High Court judges rather than state commission. You can have various wings. Like National Commission can sit, main principal bench can sit in Delhi, and then you can have throughout India branches. But I am much more in favor of National Appointments Commission like UPSC rather than making this state level. That will really tend to the fragmentation of the judiciary.
In India, the judges and the population ratio is one of the lowest democracies. Supreme Court has already passed several judgments that you increase the ratio. At least 50 judges should be for 10 lakh people. But the government is keeping quiet on that. But do you think by this Judicial Appointments Commission, once is put in place, more number of judges can be appointed?
Commission, again, like UPSC, will have the power to recommend. Again, it would be the political will of the government to appoint them in time. Because so many times recommendations are made and the government does not act in time. So it will definitely help to have a regular National Appointments Commission which would be working on a normal basis. Right now, it's much more an ad hoc judgment when judges are appointed. Take, for example, in America, in the whole year, only 150 cases come before the Supreme Court. 9 judges sit. In India, judges handle 70, 80, 100 cases a day. So our judges are some of the most busiest people. So having a Judicial Appointment Commission, so which will be devoted to this task of appointing judges or transferring judges, is a really welcome step.
Do you subscribe to the view that government during the last session introduced a bill saying that the High Court judges' retirement age should be on par with Supreme Court judges? It should be raised from 62 to 65. But certain quarters expressed reservations. So the bill was passed in the Lok Sabha. Unfortunately, it could not be passed in the Rajya Sabha. Bill is still pending. But do you think that by increasing the age limit of High Court judges from 62 to 65, the arrears to some extent can be reduced?
This would be in fact overdue because given the longevity of the people, making arbitrary limit of 62 years is really too little. So raising it to 65 would be a good idea. Not only that, in America, judges are appointed for life. So there is the independence. Now, people by grace of God and scientific advances, these days maintain good health even at the age of 60 and 70.
But there is one view that once you increase the retirement age, then post-retirement they should not accept any post.
That would be a healthy step because then they have nothing to look forward to and their susceptibility to any kind of influence in the expectation of post-retirement post will go. So I am very much in favor of raising the age to 65 years of age for High Court judges and even for Supreme Court judges to the age of 67 or maybe 70.
But do you think that once this Judicial Appointments Commission is put in place, the judges appointed will be subservient to the government or they can still retain the independence?
There is nothing in the Judicial Appointment Commission bill which in any way reduces the status of the judges or reduces or impacts their independence because it is only a selection process. So the independence of judges will at all be compromised by this Judicial Appointments Commission.
Let us hope that the Appointments Commission will augur well for our country and we will get good judges. Thank you.
You were listening to a dialogue on constitutional status to Judicial Appointment Commission and implications thereof. The participants were Dr. Surat Singh, Advocate Supreme Court, and J. Venkateshan, Legal Correspondent, The Hindu. It came to you in the program News Analysis, produced and presented by the News Services Division of All India Radio. This program is also available on our website newsonair.nic.in. You may email your opinion about the program at airnsdtalks@gmail.com.